idea. Okay, idea can be patented. Idea, if you have any idea, you can patent it. You can file a patent for idea. No. Why so? We will discuss it. Law of nature is discovery. Okay. Scientific principles, mathematical rules are there. Okay. Mathematical rules, scientific principles, laws of nature, discoveries cannot patent, cannot find. Okay. So what you can find? The first condition is it should be a novel idea. Novel creations. Novelty should be there. It's a prime conditions. First condition, it must be a novel creation. Okay? Novelty should be there. Other thing is non-obviousness. It should be a non-obvious creation. Non-obvious means non-obviousness means what you are saying that what you are creating or what you are going to file a patent or what you are saying that this is the creation, this is the invention, then the skilled person in that area, the persons or the community or the professionals in that area, okay, they are not aware about your invention. They cannot do easily what you are doing. Obvious things like a fan you have created, fan is an invention, suppose fan is an invention and 3 spokes are there. You are saying that 5 spokes will be there and these are the benefits. It's an obvious thing. Okay. Means some applications you have developed and some applications you have not included in the inventions because it is a very obvious or very common thing you can add later on. Okay. And you came with the idea that we can add this one and these are the benefits. Okay. Very obvious thing that if you have 5 applications in the software and the 6 and 7 related applications you can add. This should not be there. Okay. Other one is industrial applications. So when we are saying that this is a patent, this is a copyright, this is a trademark, these are the things IP rights we have, and we are not using these rights of the community, of the people, of the society, then it is useless. But why we are doing these things? Why we have a different type of innovation? Why we have a different type of products? Why we have a different type of new technologies? The society, right? For the benefits of the society, for the benefit of the industry, for the benefits of the different applications through these inventions for the society. Okay. So industrial applications should be there. If you are creating something, then it must be used by in the society, must be used by the society. Right? So these basic conditions must be there. If your invention, if your creations following these things, these 3 conditions, then it will be fine. After filing, there is a different type of processes or different type of steps before granting the patents. Okay. So if we are talking in India and other countries and in USA, different steps, different procedures are there for the granting of the patent. So what we cannot file what type of project or we have this. So what are the parts of a patent? Okay. If we are saying that if we are writing a research paper in different sections, different parts in a research papers, okay? So similar type of things when you are writing a patent documents, these terms are very much defined internationally. For each sections, you have to fulfill the defined things. If you are writing anything in a different section, mismatch in the defined thing, not then your citation will be not accepted. Every sections in which required field is very much defined. Okay. So we have to follow it. The major portion, the major things in these forms is a claim. Okay. So what is a claim? It's a very much important and it is a major part of the application, major part of the inventions. Okay. So when you are writing a claim, it's a very much important that you should very much aware about what is the composition of the claim. Because this claim, on the basis of this claim, your patent will be granted. Okay. So claim is a very much important part and claim is a very much critical part also when you are writing application or writing a patents. Okay. So different types of patents already we have discussed further. For getting it or managing it or getting benefited from it. Okay. So these facilitation centers are providing support for maintaining or generating and for different types of benefits of the IPRs. So any individuals, they can reach there in the facilitation center and then they can get benefited from it. Okay? So everything from the start of the basics, they can guide you from the beginning. Okay? For the IPR generation and management of the IPR. So what is the basic of IPR? What is the basic terms of IPR? Intellectual property rights, when I am saying intellectual property rights, means it is three terms. Okay? Intellectual property and rights. So intellectual means anything which is created by your mind, the creation of the mind. Okay? Anything created by your mind. Body, you can say body creation. Okay? It's creation of the mind. Property means sampada, your property. Okay? So anything which is created by your mind is your property. Okay? And then its last term is rights, means adhikar. Body sampada adhikar. So who will give these rights to you? Okay? So states, means states, when I am saying states in the country, institution. Okay? So country means states is giving you the rights. Okay? That this property, this creation of your mind is yours, and nobody can steal it, nobody can change it, nobody can manufacture it, nobody can do anything without your permission. It's your property. Okay? So the state is giving the authority, the state is giving the right to the personals or innovators, you can say. Okay? A right to protect the creation, to manage the creation, to get benefited from this creation. Okay. So as I said in earlier slide, different types of intellectual property rights we have. Okay. So we will discuss. So what is intellectual property rights? As I said, intellectual property rights is the creation of minds. What you have created, this is your property. Okay. So IP rights. So mainly in a broader area, if we are talking about the broader area of the IP rights, okay, or IP, intellectual property. So we are categorizing it into two main parts. Okay, one is industrial property and another one is copyrights. Okay. So industrial property are different forms, papers when you are writing a thesis, the intake thesis, master thesis, or PhD thesis. Okay, you already know about the copyrights, I think. And other is industrial property. Industrial property means when we are discussing industrial property in different forms. Okay, as I said, it's a creation of mind. Okay, the creation of minds means different types of things, different type of application, different type of creation you can do. Okay, you can write anything. As a poetry, as a story, as a thesis, as a musicians, you can create a music, compositions you can do. Or you can manufacturing something, you are doing something, means creating something which means the product in a way of product. Okay, some mechanism you are creating, some process you are creating. So different types of things you are creating through your mind. Okay, so these things, these creations, different types of creations, you are categorizing into different forms of IP rights. Okay, means how many things you can create through your mind, you can categorize it into different forms of IP rights. As I said, you can write something, you can create something as a product, or you can create something like a process, mechanism, business models, different type of things you can do. Okay. So how you will protect these creations from others? Others means your competitors, your colleagues. How we can manage it, how we can protect these creations. So these creations we can protect through the IP rights. Okay. So industrial property, if you are saying inventions, we are going to discuss about the patents. Patents are very important part, a very important thing nowadays, and very important IP rights. Trademarks, industrial designs, geographical indications, okay, layout surface designs, different types of industrial rights, industrial property we have, and another one is copyrights. So, as I said earlier, the copyrights is the creation of mind which is related to the literary art. Okay, you are writing something, you are composing a music, you are performing somewhere, as a musician or an artist, you are painting, you are painting something. So these type of things you can do the copyrights. The software you are writing, okay, software code you are writing. These type of things you can do the copyrights. The software you are writing, okay, software code you are writing. So these category, when you are doing these type of things, then you can copyright these things, these creations. Okay. So every IP rights, every intellectual property having some certain types of period or protections. So when you are getting certificate, when you are getting the rights from the government or from the state, then it is mentioned the time period of the protection. Okay. So like a patents, okay, like a copyrights, like a trademark, industrial designs, all having some certain period of time. Means this period of time is yours. It is yours. This creation is yours. Nobody can do anything in and saying that means the processing, the manufacturing, then selling, licensing, using. Okay? Nobody can do in this period. Like a patent, we are saying that 20 years from the filing date. Filing date, when we will discuss about patents in detail, then we will discuss these things. Okay? So, different kind of things like property rights protected under intellectual property, these are the different forms of the IP rights under which we can protect the different type of creations. Okay? So, like I said earlier also, it's patents, copyrights, trademarks, industrial design, trade secrets. Very important. Trade secrets is very much interesting rights. Trade secrets. Trade secrets. Okay. There you are not disclosing anything and you are protecting your rights. Then we will discuss in various trade secrets. Then we will discuss its property. Okay. Geographical indications and plant varieties, biological diversity, different type of habitats where you can protect your creations under these things. So patents. First is patents. So what is a patent? Actually, when we are talking about IP rights, then patent is the most important IP nowadays. Okay. So patents. What is a patent right? So for filing a patent or getting protected under patent, there are some certain rules, conditions are there. Okay. So when you are filing for a patent, then some conditions are there, and which conditions you have to fulfill. Then you can file a patent. So it is giving you, means the state is giving inventors or the innovators exclusive right. The term is very important. Exclusive rights means it is only for you. It's yours, your creations. Okay. So when you are saying it's exclusive rights, then you are defining that these creations, this property is mine. I have invented, I have created this. Okay. Or nobody means it's normally we are saying patent rights is a negative rights. Okay. It's a negative rights means you are what you are doing that nobody can touch this property. Okay. Nobody can do anything means you are saying nobody can use this one also. Nobody can sell it out. Nobody can license it. Okay. So everybody was saying it's my property and you are not allowed without my permission. So it's a negative right. Okay. So in a legal term, when we are saying the patent rights, it's exclusive rights and it is also a negative rights. So for the patent filing, you have to follow some conditions, some term conditions. Okay. So we will discuss later. So what can be patented? Okay. So inventions, what you are going to patent is it should be must be inventions. Okay. Idea. Okay. Idea can be patented. Idea. If you have any idea, you can patent it. You can file a patent for idea. No. Why so? We will discuss it. Law of nature. It's discovery. Okay. Scientific principles, mathematical rules are there. Okay. So mathematical rules, scientific principles, laws of nature, discoveries cannot patent, cannot find. Okay. So what you can find? The first condition is it should be a novel idea. Novel creations. Novelty should be there. It's a prime conditions. First condition, it must be a novel creation. Okay. Novelty should be there. Other thing is non-obviousness. It should be a non-obvious creation. Non-obvious means non-obviousness means what you are saying that what you are creating or what you are going to file a patent or what you are saying that this is the creation, this is the invention, then the skilled person in that area, means the persons or the community or